So enough now from me. I want to kick off proceedings by introducing our keynote speaker for this morning. And that is, of course, Anna Longley, the Assistant Commissioner and General Counsel at the Australian Charities and Not-for-Profits Commission. Let me just say at CLANS how grateful we are for the long-standing support and collaboration of the ACNC. And of course, as many of you would know, at past conferences, we've had the great pleasure of hearing from Dr. Gary Johns, the ACNC Commissioner. And Gary, it's good to know that you're here with us today. And before him, of course, the inaugural Commissioner, Susan Pascoe. This year, we're delighted to welcome Anna to offer her thoughts on the conference theme. Anna is well known to most of you, of course, and needs no introduction. But for those who might not have met her, her role at the ACNC entails general oversight of the legal and regulatory work of the Commission. She has an extensive background in public administration, and before joining the Commission, she worked for some 16 years at the Australian Taxation Office, leading assurance and review work on high wealth individuals, private groups, and not-for-profit entities, and developing advice and guidance and determining objections. She has overseen fringe benefits tax for the ATO. You have to get some sort of medal for that. And in the charity sector, Anna also has considerable experience volunteering for and on the board of community legal centres. Anna, we're delighted you're with us today. And I'd invite you now to offer some thoughts on our theme of government and the charity sector. Over to you, Anna.
Thank you very much for that, Matthew. I would like to begin today by acknowledging the First Nations people of Australia and Aotearoa New Zealand and pay my respects to elders past and present. I'm joining today from Wurundjeri country. I really appreciate the opportunity to present today. It is a shame that we're not in person. I think I'm much better in person, but we'll do our best. It is interesting, Matthew, when you said lots of people know me. Unfortunately, my plan was to get out and about and meet a lot of people last year, and clearly COVID had other plans for me. So that didn't quite come to pass the way I had anticipated. But I do agree that the collaboration between CLANS and the ACNC is extremely important, and the insights that members offer in various forums is really of great use to us, and particularly in understanding how we're regulating and how we can improve things, and we always welcome that feedback. I'll be focusing on some of the legal and legislative issues that have arisen over the past year. There's been many and varied, and I won't be covering everything, but a little plug for our ACNC Regulators Day tomorrow. You'll have a chance there to have a further opportunity to hear about regulatory matters that are impacting the charity sector and other pieces of work that have been keeping us very busy. If you haven't joined that yet or signed up for that yet, I do encourage you to. I also wanted just to start really by thinking about how we approach decision making in the ACNC, because I think that really is a very important part of how we operate and our role within regulating the charity sector. As set out in our legislation, we've got a mandate, as we all know, to maintain, protect and enhance public trust and confidence in the sector. And we're very committed to the fair and reasonable regulation of charities. So we continue to ensure that all our administrative practices support consistent and robust decision making that takes into account relevant circumstances and current law. It's free from bias and is independent. Decisions are based on impartial legislative interpretation and relevant case law. And where the circumstances of a case are particularly novel or decisions have significant consequences, perhaps a decision to refuse to register or a revocation of charity registration, these are carefully considered before decisions are made. In the case of decisions about compliance with registration requirements or adherence to governance standards or external conduct standards, we follow our published regulatory approach statement to ensure that actions we take are proportionate to the identified problem. Our preference is always to work with charities to rectify any compliance issues. And I consider that that administrative approach is really vital to ensure continued trust and confidence in the ACNC as a regulator. With all of this in mind, I know one matter of great interest, which is possibly an understatement, is the amendment to Governance Standard 3. This was tabled on Tuesday in Parliament. On the assumption that it's not disallowed, we're preparing obviously for it to come into effect, hopefully at the start of September. And therefore we're preparing guidance that will assist charities to comply with the amendment. I'm very well aware that this has caused great concern to the sector. I won't be commenting on the purpose of the legislation, but I can comment on how we intend to administer it, which I think really is quite an important element, of course. Importantly, we will be abiding by our regulatory approach statement. And if a matter arises that questions a charity's compliance with Governance Standard 3, amended Governance Standard 3, we aim to work with the charity to understand the circumstances and take action that's proportionate to the risk to beneficiaries, charity funds, and trust and confidence in the sector. It will also have to stand up to the principles of sound administration, meaning that decisions will need to be evidence-based, proportionate, and able to withstand scrutiny. It's extremely important as an administrator. We do not intend to take action where a charity has acted inadvertently, and neither do we intend to take action where a responsible person or an employee of a charity is acting purely in a personal capacity. Our view is that if a charity already has robust procedures in place to ensure that it complies with laws, it's unlikely to need to further implement processes as a result of this amendment. I will also just turn to matters within the ACNC, and that starting with charity registrations. We're up to over 59,000 charities on the register at the moment. So it's a number that has been steadily growing, and it's certainly been keeping our registration team very busy. As always, we receive a mix of applications. Some are quite straightforward and some require further information before we register them. Some are raising new issues relating to Charities Act or the law on charitable purpose. And we've had a small number of applicants seek external review of our decisions over the past couple of years. Earlier this year, we received a decision of the Administrative Appeals Tribunal in Women's Life Centre Incorporated in the ACNC. This was our second decision on a review of a decision. Women's Life Centre had applied to be registered as a charity with the subtypes of advancing health, advancing social and public welfare, and as a PBI. We registered it as a charity but refused the application to be registered as a PBI. The Tribunal affirmed the Commissioner's decision largely on the basis that its activities were not targeted at persons in need of benevolent relief, and its activities generally went no further than the provision of emotional support and assistance of the kind that's been described in other cases such as Marriage Guidance Council and Adoption Privacy Protection Group. And the Tribunal noted in its decision that consideration should be given to Women's Life Centre's constitution and activities in order to understand its purpose and character. And so that gave us a bit further confirmation about the way that we do administer the law, and that we really do have to consider both the constitution as well as activities of a particular entity. We've currently got 3 other matters heard and reserved before the AAT, and all of those arose out of registration decisions. So from an ACNC point of view, we're quite busy in the litigation front. I also wanted to touch on Commissioner's interpretation statements because these provide guidance to charities and their advisors and the public about how we understand the law, and we do treat them as binding on ACNC staff. We're very grateful for the feedback that we've received in relation to the Commissioner's interpretation statement on the provision of housing by charities, which we've incorporated into a draft revised CIS. And those revisions are primarily by way of clarification. So we've included a section on home ownership and when charities may be able to assist beneficiaries with home ownership without jeopardising charity registration. And we do appreciate that this can be a difficult area for charities involved with for instance, state government social housing schemes. We've also expanded the discussion on undertaking commercial activities, which I think is also very important for this part of the sector as well. We've sought final feedback on that CIS by the 16th of August. On another Commissioner's interpretation statement, we are looking to review the interpretation statement on public benevolent institutions. I do realise this has been a long time coming, and I do thank you for your continued interest in this. The version published on our website, importantly, does remain the current document at the time being, for the time being. And we're considering the submissions that have been made and the statement of our position very carefully. It's a highly sought after subtype, and there are differences of opinion as to what is acceptable for a public benevolent institution. For instance, we do have a number of applications that I would describe as challenging the extent to which an entity can engage in activities directed towards the broader population or influencing government policy and still fall within the definition of PBI. I think it's a really interesting area to be thinking about, and I do expect that there may be some developments in that area, given some of the litigation we've had. It's therefore very important to us that we consider any revisions to the CIS very carefully, and they explain our position very carefully. Clearly, there's been a lot of change over the last year. I haven't got to all of it today. I haven't, for instance, talked about Governance Standard 6, which does impact only a small number of charities, or the requirement for the ACNC to link to the Australian Electoral Commission information about electoral expenditure and political donations. Links to relevant charities went live on the 30th of July. There's certainly been a lot of change over the past year. There's certainly been a lot of change over the past year, and so we expect to see a little more with anticipated implementation of the legislation review and DGR reforms. I did also want to mention that there is one matter currently under consultation in relation to reform of the ACNC secrecy provisions. Most of you will recall that the panel who conducted the ACNC legislation review recommended an expansion to the ACNC's power to disclose information. And so I do encourage you to provide input to that consultation on what those changes may look like, and that will help frame any law change. Finally, I just wanted to acknowledge that I am conscious, I should say, that it's difficult for charities and their advisors to adapt to changes in the law and administration. So we remain committed to providing education and guidance to assist charities to understand and meet their obligations. This group is, of course, extremely vital in advising and assisting charities, as well as providing input on the regulation of the sector through engagement with regulators such as the ACNC, as well as government. So thank you very much for the opportunity to speak this morning. If there are any questions, I'd be more than happy to take them.
Yeah, thank you so much, Anna. And as Anna has indicated, he's happy to take some questions. Could you either use chat or just raise your virtual hand so I can see who might have a question?
I did just see also that Miles put up the case summary regarding Women's Life Centre. I agree that is a really good case summary. So it's a good place to go and have a look and see what happened with that case.
Yeah, and thank you very much for doing that, Miles. Well, while colleagues reflect on questions, I might kick off with one, if that's all right with you, Anna. And it would be interesting just to hear your thoughts on where we are in Australian law and the interpretation of the law around purposes and activities, because it's an issue that comes up all the time. And, you know, on one view, there's perhaps not a great deal of guidance in the case law or the Act for that matter on, you know, how that distinction plays out and what it means for characterising a charity's purpose. And I just wondered if you had some reflections on that.
Yeah, I think it's a really interesting question. So thank you very much. I think one of the issues, and I kind of reflect on this given my background in tax, we've got very young legislation still. And so while there is a lot of case law, there's not necessarily much case law, currently 2 cases, really past, subsequent to the Act being enacted. So I think as we go forward, we may well see a little bit more in that area where we're actually having our Act interpreted. And I do obviously understand the difficulties with litigation when we're litigating with charities that have particular purposes that they have to put their funds to. So I do appreciate there are difficulties there. But I suppose in terms of purposes, what I would say, and it did come out in the Women's Life Centre case a little bit, is that it is really important that we're looking not just at the Constitution, but also the activities and how they do interrelate and demonstrate a purpose of a charity. And I do also appreciate that that is sometimes a very difficult it's a very difficult determination to make. It's also the reason why we will often ask a lot of questions regarding registration applications, because sometimes the purpose isn't always clear on its face, and we do have to ask those additional questions to understand and really get to the bottom of what the purpose might be. And I think the other interesting thing that I have been reflecting over the past year or so is the difference between charitable purpose as it's understood and my word only, motivation of a charity. So the reason that it might do things may not actually be its charitable purpose as defined. So I've found that a really interesting distinction, I guess, to think about.
Yeah, great. Thank you so much, Anna. Now, I think there might be a question from Ian Murray.
Thanks, Matthew, and thank you, Anna, for your presentation. That was fantastic. Really appreciate that. I guess one question I was wondering about, and apologies if this has already come out on the ACNC website, is, but I guess we're starting to see a number of charity cases work their way through, and I'm just conscious there was that funding that the government had given the ACNC a year or so ago that was potentially, that could be used for funding litigation test cases and the like. And I was just sort of wondering whether there'd been any developments in the internal ACNC thinking about when, in what circumstances that funding might be used for test cases.
Yes, thank you for that, Ian. The government response to the legislation review actually specifically said that it wouldn't be funding test cases. And so it's not an amount that's used for funding test cases as such. We don't have that program. And I know that the ATO, for instance, does have a test case funding program. That's not something we're actually able to fund at the moment, unfortunately. But I suppose we are very conscious always of the costs and impacts to charities or entities that are seeking charitable registration when they are looking to litigate. I think if we do think, though, about costs, I'm not necessarily, I think we would have to consider in the appropriate cases what we would enter into a cost agreement on. So what is an appropriate case would depend on the circumstances of that case and whether it's a matter that we think would be valuable to have judicial consideration of. And so that's sometimes a question that's, or often a question actually, that's very difficult to answer prior to understanding how a case may be put before the court, but we would consider it in appropriate circumstances.
Terrific, thank you, Anna. I'm just checking the chat to ensure that we don't have any last questions, and I can't see anything there, so that's pretty good timing actually, because we're just on 10. So look, Anna, thank you so very much for joining us this morning, and hopefully you'll be able to hang around for some of the rest of the day. And we certainly all look forward to engaging with you and your colleagues further tomorrow at the regulated day. So join me with some sort of Zoom hands to say thank you to Anna Longley.
Thank you very much for that, Matthew. Unfortunately, we're unable to provide anyone catering tomorrow.
Yes, bring
Next
your
year,
own.
hopefully.
Yeah, we look forward to that.